everybody. This is Samantha from the Law Offices of Samantha Wolfe, and I'm here today for part two of our estate administration virtual seminar. So, part one, I had taped. It's Easy Path to Estate Administration, where we talk about how the executor gets appointed and all the opening steps that you need to in order to get that appointment. And today we're going to go over part two of the estate administration. So, I'm excited to do that. We will do a final, a part three. So make sure to check that out. But we wanted to break it down into smaller pieces, maybe a little bit easier to digest and for people to find information. So with that being said, I'm going to go ahead and share my screen here, and we're going to do part two. So how does this administration thing work? So part one was all about the appointment of the executor and kind of what you needed to do. Like I said in the last segment, once you've been appointed, that really then gives you the green light for administration. So today we're going to talk about how do you administer an estate. So as we've talked about, when we do these seminars, we do it as part of our mission. We do feel like it's really important to make sure to get education out there, to provide for our clients and referral sources education so that they can learn about the different areas of law that we do. Okay, so you've been appointed as the executor. What do you need to do? So the first thing that you have to do is you have to provide the required notices. So when someone passes away and we have the executor getting appointed and they have those letters of testamentary saying they've been appointed, what do they need to do? They need to advertise the estate. So the estate advertisement is just basically outlining that this person has passed away, and you're going to run it 3 times. So once a week, for 3 consecutive weeks, and it's going to appear in 2 publications. So typically it's a legal journal and then a paper of general circulation. And the reason that you're doing this is you're providing notice to the creditors, and providing that notice under Pennsylvania law then gives them 1 year from the date of the advertisement to come forward with any claims. These creditors can come forward. After that year, they're barred from bringing any claims. So that's why it's so important to do this notice, this advertisement, because you want to stop those creditors from being able to come forward. You also have to provide notice to the beneficiaries and to the intestate heirs, meaning that if I had a client that had children, but for whatever reason disinherited the children under the will, under Pennsylvania law, those children still are required to get a notice that the person has passed away. So once you provide the notice to the beneficiaries, you then have to file a certification with the Register of Wills saying that you as the executor provided the notice to the different beneficiaries, and this is the date you provided the notice. You typically want to notify the 3 credit reporting agencies so that they don't issue credit under the decedent's Social Security number. We recommend that you notify the Department of Motor Vehicles, the Pennsylvania Department of Human Services, and we just make sure you want to consult with Pennsylvania law and make sure that you're following all the court rules for the notices. And that's where typically you engage an attorney to make sure that you're doing all the notices correctly, filing them properly. Additional notices, you might have to provide the Attorney General for Pennsylvania if there are charitable bequests. Notice to the AG if the interest has a statutory heir and unresolved inheritance tax issues. You have to notify the Attorney General. You have to notify the Pennsylvania Department of Revenue if the decedent died while they were residing in the state institution. You have to notify Pennsylvania Department of Human Services if the decedent was receiving Medicaid or medical assistance during the last 5 years of life, if they were 55 or older. We typically do it just part of our estate administration because more and more people are passing away in facilities, and so we want to make sure we're notifying the Department of Human Services if they were in a long-term care facility. We also have to notify the Veterans Administration if the decedent was a veteran or a minor of a veteran and receiving benefits. Let's talk about real and personal property and how to get rid of the decedent's stuff. So tangible personal property. Typically, you're going to get an appraisal for anything of value or anything listed in the will, and you have to do that for inheritance tax purposes. Now, Pennsylvania does say you can use garage sale values in order to do that. Now, if we have a collection or something that would be worth something, that's when we're going to get the appraisal. Safe deposit box, you want to make sure you've checked the safe deposit box for any type of personal property. Coins might be in there. That's a common place for people to store coins. And then you want to make sure if there's an in-kind distribution, you want to make sure, does the will discuss, does that reduce the beneficiary's share based on the value as appraised? Or is that just go to them as a specific bequest, for example? You have to think through expenses of storing, delivering any of those personal property items if we have people that are out of town. And how are the Pennsylvania inheritance taxes paid? Typically, the will would say, is it allocated to the residue? Is it allocated to the bequest? So you want to make sure that you're looking through the will to make sure you know, having your attorney look through the will, making sure you know. Property that has no value, things like clothes, for example. Family can get together, can clean the house, you can rent a dumpster, you can have a yard sale, you can use a local auction house. That can be really helpful. We've had a lot of clients have success with auction houses because what the auction house is able to do is to group together assets and make it so that things that you wouldn't think you could sell because it's part of a larger lot. And so I always encourage people to reach out to auction houses. We have great experiences with those locally here that we've worked with. Now, if there's a minor, the personal representative or the executor is going to have to hold or give to the guardian of the minor until they're 18. That's why it's so important to have a custodial clause in the will. Who is the custodian for anyone who's underage? So we want to make sure that the executor is following those provisions. The other thing we want to check is, does the will allow the executor, the personal representative, to create a trust, an able account, any of those type of things that would help our beneficiaries? Firearms are a big thing here locally. We have to make sure we secure those firearms. We have to make sure the beneficiary who might be receiving those firearms can actually possess those firearms. We might want to use a reputable gun store for valuation or procedures. They've been really helpful when we've administered an estate. And then if we do have clients that have a large collection of firearms or certain firearms based on the class of firearms, they might need a gun trust in order to make sure that everything's being handled properly. If there's real property, land, then we need to say, if they're deeds. Do we have deeds? Verify the title. If it's in both husband and wife's name and one spouse dies, you do not need to redeed it when the first spouse dies. But you want to make sure you're checking the deed, because how is it titled if it's a non-spouse? So for example, if it's two siblings, do they own it as joint with right of survivorship? Do they own it as tenants in common? So we just need to make sure. If it's owned in a trust, do we need to administer the trust? With real estate, with real property, you want to make sure that you're either appraising it or you're using the tax assessed value times the common level ratio factor. So you don't have to get the real estate appraised. The reason that people do get it appraised is because the basis is set at the time someone passes away. So if I have somebody, a decedent died and they owned real estate, whatever the value is when that person died is the basis for the beneficiary. And so if then the beneficiary sells it, they only have to recognize the difference between what they're selling it for and the fair market value of the property when the decedent died. So there's not as much capital gains there. So an appraisal would allow us to make sure we're getting the highest value for that stepped up basis, but you can use the tax assessed value times the common level ratio factor to determine the value. Typically that value is going to be less than an appraised value, so it means less inheritance tax, but then it means that you have less basis or lower basis in the property. So if you go to sell the property, there might be more capital gains that you have to pay. So you want to make sure you're talking to your attorney about those issues when you're doing your estate planning, because it's a lot of times it's the difference between the inheritance tax versus the capital gains if your beneficiary would sell it. For example, if my dad leaves me property and I pay 4.5% inheritance tax if I receive it when he dies, but then my basis in the property is whatever the fair market value was on the day my dad died. So if I turn around and sell it right away, I'll have zero capital gains. So I paid 4.5% tax, but then I don't have any capital gains at 15%. If instead my dad goes ahead and transfers it while he's living and survives that transfer, 1 year. So he deeds it over to me and then survives it by 1 year. I don't have to pay the 4.5% inheritance tax, but then when he dies, I don't get the stepped up basis. So whatever my dad's basis or whatever he purchased the property for becomes my basis. It's called carryover basis. So if he purchased the property for 100,000, my basis is now 100,000. When he dies, if I sell it, I'm going to recognize the difference between the sale price and the basis. Okay, so I may have avoided the 4.5% tax, but I'm now going to have to pay capital gains tax at a 15% rate. So 90% of the time when I meet with clients, they come in saying they don't want their kids to pay inheritance tax, but paying inheritance tax may actually be the lesser tax. And so they actually end up wanting them to pay the 4.5% tax and not pay the 15% capital gains tax. If you have questions about basis, make sure to call our office or talk to your attorney about it because that can get a little tricky. If the personal representative, the executor, wants to buy the property, then we might need to include that language in the will as an option to purchase, because otherwise they have to get court approval, they have to get appraisals. So it just makes it so much easier if we know the executor is going to want to purchase the property to go ahead and put that provision in the will so we don't have to go through all of that. We also have to consider Pennsylvania realty transfer tax. So there's no realty transfer tax if there's a beneficiary under the will that's receiving that property and they're not buying it. Then there's no realty transfer tax. So we also want to think through that. The executor can always renounce if they're buying the property so that way they don't have to get court approval. You can do real estate. You can sell it with an auction as is. Estates don't need a seller's disclosure form, so if the personal rep is not at the closing, you can get a power of attorney to sign the docs at the closing. So it does make it a little bit easier as far as the closing. Let's continue talking about real estate. So mandatory mediation, recommend waiving in a standard sales agreement if the executor is out of state. The executor won't have to attend the mediation. Invest in property before the sale or sell it as is. So these are things that we have to talk about with the executor. Do they want to fix it up and make renovations, or do they just want to sell as is? Pennsylvania inheritance tax would be a lien against the real estate until it's paid. So that's why it's so important to get the inheritance tax paid as soon as possible so that we can either distribute the real estate out or sell it. And that can be really important because remember, there's going to be insurance, taxes, maintenance on the property. So the sooner you can get out of the estate, the better it is for those costs that might be being incurred. Most closing companies do hold money in escrow until we get the all clear from Pennsylvania with the appraisement saying that there's no inheritance tax that's due. They do have us hold it in escrow. Even if we can show that we've paid the inheritance tax on the value of the real estate, they still want it to be held in escrow. If you're out of state, then you want to make sure you're disclosing the property on the inventory. Here in Franklin County, we do an inventory anytime there's real estate in the estate. If not held in trust, then an ancillary probate might be required if it's located in a different state. So that's where you start talking about trusts and being able to make it easier to administer it. Let's talk about intangible property. So this would be retirement accounts, stocks, bonds, annuities, life insurance, bank accounts, all that good stuff. Many of those are going to pass by beneficiary designation, not by the will. But there still might be inheritance tax. So even if it doesn't pass by the will, you might be reporting on the inheritance tax return and you need that documentation that shows the date of death value in the beneficiary. You want to make sure you're disposing of the decedent's credit cards, and you want to make sure you're closing the bank accounts and transferring it to an estate account. So for example, if we have a bank account that was in the decedent's name, as soon as they die, that's frozen. We get the executor appointed, they provide the bank with the documentation, they close out the decedent's account, and they open one in the estate account. They have to get an EIN, all of that good stuff. Retirement accounts, typically we have a financial advisor, so we're talking to the financial advisor. They can help us transfer assets to the beneficiary, fill out the claim forms. If there's no financial advisor, we can contact the company and help the beneficiaries fill out the claim forms if we need to. If it's a regular IRA, not a Roth, and a 401k, there might be deferred federal and PA income tax that would be due. Life insurance and annuities. So the good news is with life insurance is there's no Pennsylvania inheritance tax for life insurance. So that's wonderful. It's the only asset that we have in Pennsylvania that's automatically not subject to inheritance tax. Sometimes that is really helpful because it might provide liquidity for the estate, meaning to help pay the inheritance tax on other assets, to help pay for funeral or burial arrangements. That might be used for. Now, you will need to file a claim form with the institution. So you fill out this claim form, submit them, then they cut the beneficiary a check. You don't even report the death benefit proceeds on the inheritance tax return. Annuities, though, there would be inheritance tax and they are tax deferred. So typically there's federal and Pennsylvania tax and also inheritance tax on annuities, but it typically passes through beneficiary designation. The inheritance tax, so federal estate tax, so that's a tax on your right to transfer assets when you die at the federal level. The threshold is $15 million starting in 2026. So as long as a married couple doesn't have an estate larger than $30 million, we don't have to worry about any federal estate tax. But Pennsylvania inheritance tax, there's no threshold. You have to file a return even if no tax will be due if the assets need to be disclosed on the return, and applies to both probate and non-probate assets. The inheritance tax rates depend on the beneficiary's relationship to the decedent. So if it pays to a spouse, it's 0%, pays to direct lineal descendants or to parents, so up or down your line, it's 4.5%, 12% to siblings, 15% to anyone else, including nieces and nephews. Charities are exempt. The Rev 1500 is the Pennsylvania inheritance tax return. So that's the form that Pennsylvania requires you to fill out as the executor, disclosing the date of death values. It is due, the return is due with payment within 9 months of the date of death. Like we talked about in part 1, the part 1 presentation, there is a 5% discount on the tax that's due if you pay within 3 months. The inheritance tax, you have to fill out the return, plus the Department of Revenue wants to know what assets, what their date of death value is, who the beneficiary was, and we need documentation to support that. So you then can take deductions on certain expenses, and so then that tells you what the tax that's due. Usually it takes the Pennsylvania Department of Revenue 4 to 6 months to review the return and issue the appraisement, and technically the estate is not completely wrapped up until we get that appraisement. Income tax, you want to make sure the decedent files a final federal and Pennsylvania income tax return. That's due by April 15th of the year following the date of death. Typically, you're going to have an accountant or your tax preparer, your CPA handle that. There may also be a fiduciary return, meaning that the estate may have an income tax return. Because if we have a client who died March 1st, there's going to be a personal income tax return that's due from January 1st to March 1st. And then once they've died, there might be an estate income tax return that has to be filed for any income generated from March until the end of the year. So that's why we partner with our accountant friends and have them help us with any tax returns. So next steps, if you have questions, you can always reach out to our office at 717-655-2676 to schedule an initial consultation. This was part 2 of our estate administration. We have a part 1 that talks about how you get appointed as the executor. This was starting the estate and how you kind of get the ball rolling. And we're going to do a part 3 that talks about wrapping up the estate. So be sure and check that out. You can always find our videos on YouTube. So please run over to our YouTube channel and check out any of those videos. We look forward to seeing you in part 3 of the estate administration process. Thank you so much for joining us. Take care. Bye-bye.